So it's my privilege to introduce to you Professor Hadley Arkes, who's the Edward Ney Professor of Jurisprudence at Amherst College, where he first started teaching in 1966 as a child prodigy, as we all know. He's the author of a number of important books from Princeton University, The Philosopher in the City, First Things, Beyond the Constitution, and more recently from Cambridge University Press, Natural Rights and the Right to Choose. His articles appeared not only in scholarly journals, but also in the Wall Street Journal, Washington Post, Weekly Standard, and other public venues as well. He was educated at the University of Illinois, a PhD at the University of Chicago under the celebrated Leo Strauss. So, I should mention also he's the founder at Amherst of the Committee for the American Founding, a group of alumni and students that are seeking to preserve at Amherst the doctrine of natural rights that were taught by the American founders and also by Lincoln. And Professor Arkes is one of, if not the, leading natural rights thinker in the country. And so we're very, very privileged indeed to have him speak for us. Hadley.
Thank you. David. Thank you. The leading natural rights, as we say in Amherst, I think you've got the wrong Reverend Jackson. I just realized that this was my only second time in Austin in my life, and maybe somebody will prod me telling my favorite stories about second times, but I recall last time I was here, I was stopping in San Marcos to give a talk for Ken Grasso with a talk that had many turns. Then I was told when I got off the plane that 200 undergraduates were going to be there that night. I thought I'd better take advantage of my time and sketch out a different kind of talk, not scaled down. And then I went in and I told an old story from a clipping that Mike Ullman had made for me from the New York Times, from the Metropolitan Diary, sketches of life in the city. And one from several years back read in this way. It said, "Dear Diary, it was midway during Act 3 of La Traviata at the New York City Opera. And after witnessing Alfredo's confession of love, the couples retreat to the outskirts of Paris. But George was appealed to release Alfredo for the benefit of his sister's prospects of marriage. Violetta's compliance, her pretended deceit, Alfredo's jealous rage, her reversal, an illness, Giorgio's sympathy, the lovers' tragic reunion, and Violetta's death. After all of that, I heard the woman behind me say to her companion, 'The same thing happened to my girlfriend Gloria.'" Two middle-aged persons laughed in that hall of 200. So I thought even the second talk wasn't going to work. So just bear down and do what you're going to do. Well, thanks for coming out on a lovely Friday afternoon. It's good to see Matt, and Kevin, and Rob, whom I see in Princeton with our seminar on First Principles, and everything you said about my work has been replicated by our dear friend Gary Jacobson, who's really an adornment to this place and whose departure has diminished the IQ in New England in his aftermath. In an old style, I'd like to begin with some things nearest at hand, and with things that don't come to us instantly as questions of moment in our constitutional law. I'd like to begin with the actor Tim Robbins. He professed himself a while back as wounded when he was disinvited from a 15th anniversary showing of Bull Durham at the Baseball Hall of Fame, and disinvited because of his opposition to the war in Iraq. The Baseball Hall of Fame, of course, is one of those private associations so thickly populating the landscape. And like many other associations, it sought to bring people together on matters of common interest, while filtering out the things that divide them, so they don't take positions on matters political. But Robbins recoiled, stung from this judgment. And with the imagination of the artist, he found in this small decision something more portentous. It was part of a repression under Bush and Ashcroft. But there had been no agent of the law silencing Robbins, threatening him with penalties for speaking his views or preventing him from proclaiming his views at some other time, some other place. And yet Robbins thought he detected in this shunning of views nothing less than a violation of the First Amendment. He found the means of conveying that opinion in his play in New York called Embedded, a kind of rather savage indictment of the Bush administration and the war, and even some critical things about Leo Strauss, my former professor. And in the midst of that indictment, he found a place for his own mistreatment at the hands of the Baseball Hall of Fame. And in an announcement that he offered gravely, at the beginning of the play, it was said, "This is the age when an institution's First Amendment rights supersede the individual's." Well, apparently, the surprise came with a certain jolt for him, that organizations, private associations, also bore certain rights under the First Amendment. The members had a claim to freedom of association, which entailed the right to preserve the character and the integrity of the association that they formed. Now, a rejoinder of this kind made to Robbins would involve an appeal to principles long settled, but often forgotten and obscured, and yet quite axiomatic, we might say. Quite axiomatic in the first principles of a constitutional order. The leaders of the Baseball Hall of Fame may not recall, but the argument made on their side had been made in a famous case in the 1930s, the case of the Associated Press versus the National Labor Relations Board. But the argument was made in a dissenting opinion by Justice George Sutherland. And the case was part of one of those famous package of cases, the Labor Board cases, which marked the critical turning of the Supreme Court, the receding from opposition to the New Deal. Now, this was 1937, and the court was now upholding the reach of the federal government, or the power of the federal government to reach labor unions and private companies, under the rather implausible device of the Commerce Clause, to compel private employers to deal with unions. Justice Sutherland's argument in the case of the Associated Press was an argument cast in terms of freedom of association. It involved the freedom of a newspaper, anti-union in its political credo, to be forced to accept as part of its editorial staff people who were militantly pro-union. My own surmise is that Sutherland's opinion receded from memory because it was lumped together with many other arguments set down by the judges who resisted the New Deal, even though those judges often included liberal justices like Brandeis and Cardozo. These opinions receded from memory because they were filed by historians and certain professors of law under the rubric of dissenting arguments in decisions that lost, sign aside that lost, thought to be discredited then as the court upheld the New Deal. And the implication, of course, was that those arguments, losing politically, were also intellectually discredited or refuted. And yet, as I've sought to show in other places, that was not the case. And to a surprising extent, much of the opposition to the New Deal actually held, and that we live today, for the most part, in our daily lives, in a cast of law that was preserved for us mainly by George Sutherland and his colleagues, including his liberal colleagues, and that we would be quite startled if some of these things were suddenly changed for us. Now, I should tell you, I grew up in a house with a big picture of Franklin Roosevelt in the kitchen. And if it were not for FDR, I don't think any member of my family would be alive today. I am, as I'm constituted, a friend of the executive power. But in the course of that book on Sutherland, Gary may remember, I came across these letters in Senator Borah's files about the case of Jacob Moggett, 49 years old, and a tailor in Jersey City, who was sentenced to 4 months in jail, fined $100 in 1934 money. His wife and 4 daughters would have to take care of the tailor shop in his absence. And what had he done? Knowingly, deliberately, he had pressed the suit of one of his customers for 35 cents instead of the 40 cents mandated under the National Recovery Act to keep prices up. People seem to forget that when the courts put some of that stuff away, they never came back. And when we remember the New Deal, we remember the things that survived, and perhaps not its some unlovely moments. My main concern has been to show how arguments that were deeply compelling seem to have lost their currency or fallen out of our inventory of principles familiar, understandable, readily usable, because the cases containing those arguments have had their meaning stamped as they're placed by historians under one political rubric rather than the other. They may be classified, for example, under the rubric of a conservative court in the late 19th, early 20th century, striking down regulations of business in the name of laissez-faire. Or the court resisting the New Deal in the name of some version of natural law. And my argument is that far more has been lost than the understanding of political economy as we've fallen into a kind of groove of politically labeling and grouping these cases. My pitch here is a fairly simple one. A plea to read these cases anew, past the labels and the caricatures, simply to read them for the reasoning they contain, reasoning that we often find surprisingly new because they've been filtered from us for many years. And when we read the cases in that way, we may have an entirely different view of the project. So instead of seeing judges who are governed by the zeitgeist and their decisions explained in terms of theories of historical determinism, we see judges engaged across the generations in an ongoing conversation as they deliberate about the substantive principles of justice and the meaning of a regime of law. Now, in making this kind of argument, it's often useful to take some of these cases and translate them into terms or conditions more familiar to us and see how we react to them. And so, in recalling Sutherland's argument, or the problem that kicked in for Tim Robbins, let's imagine that we had a journal of the National Organization of Women, a journal that is emphatically and militantly pro-choice on abortion. Let's imagine that an editor of that journal undergoes a conversion and becomes militantly pro-life, anti-abortion. Now, we take it as a given that the leaders of now would sort of want to ask her to leave. Let's suppose that in that vein of Tim Robbins, the editor argued that she was being fired then, suffering a punishment because of her political opinions, and that in firing her, the organization was quite unambiguously impairing her First Amendment freedom to publish her views. Now, one of the signal virtues or illuminations in the rejoinder that must come into play here is that it reminds us that private associations cannot violate the First Amendment. Constitutional protections are protections of persons against the powers of government operating through the force of law. The First Amendment was a protection of persons, and as it turned out, a protection of the powers of the states from the reach and power of the federal government. If an editor is fired from her position in a pro-choice journal, she's not barred from speaking or publishing her sentiments in other venues, or finding a comparable position in editing or writing in a pro-life journal. To be blocked from publishing or working in one journal is not the same, after all, as being barred by law from publishing those sentiments anywhere, in any setting or public forum. And being barred by law means being barred with the prospect of suffering a serious penalty. To state the matter, though, from the other side, the axioms may accumulate in this way. If people bear a legitimate interest, not an interest, say, in hiring contract killers, but a legitimate interest, they should be free to press that interest in the political arena. They should be free to commend their ends publicly and seek allies among people who may share their ends. They may form an association of people who have the same legitimate interest they have in promoting those ends. And if they have that right to form an association, that right entails the right to preserve the integrity of an association committed to those ends. Okay? And so the irony that blew up in the face of Tim Robbins was this: if the law sought to protect Tim Robbins' freedom to make his argument, even in a private setting, the law may do that only by impairing the right of the people in that association to preserve an association committed to its own ends, and free to speak then only in favor of the ends they truly favor. Now, some friends of mine on Capitol Hill have been concerned about the dramatic political imbalance on leading campuses with only a handful of Republicans on faculties. with many large departments, as in English, showing no Republicans at all, no conservatives. There's been a rising interest then in Congress for different versions of what's been called the Academic Bill of Rights, or a willingness to use the powers of the federal government to seek some way of opening the university to political and moral perspectives that would be, as the saying goes these days, a bit more diverse. That proposal may have a sharper edge when it comes to public universities, funded, after all, with public monies. But on the main lines defining the problem, the division between the private and the public university must have a constitutional significance that endures. As a private entity, my own college, Amherst College, could insist that everyone speak Latin on the premises, hop around on one foot. You don't have to go to Amherst, no one's compelled. It could in fact decide that it regards speech critical of gay rights as speech that's no longer legitimate in this enclave, in this association. And in the same way, a Catholic university committed to Catholic doctrine may tentatively refuse to preserve on the faculty teachers of theology who would misrepresent the Catholic position, or commend to their students a doctrine that Catholic teaching simply couldn't sanction. If there's a freedom to be Catholic, there must be a freedom to preserve the integrity of Catholic teaching. Amherst College would be free to be quite as sectarian in the other way if it indeed were to acknowledge that it's become a kind of a political seminary or an avowedly sectarian institution with no apologies, no pretense to being anything else. But, as we say, sufficient unto the day is the evil thereof. So I'll leave this one aside. I would simply say again that George Sutherland's dissenting opinion in the AP case in 1937 is the opinion that explains more persuasively than anything else the axioms that protect the pro-choice journal and the private liberal college. Now, if I had the time here, I'd make use of the same device I used here with the labor case. And I would cast in contemporary terms, again, the holdings of other older cases from the time of the New Deal, arguments assumed now to be discredited. And I think one would find again that as we reasoned about the matter anew, our tendency is to come down on the side of the argument that the historians have assumed to be rejected, with this added twist that we have a hard time now imagining that anyone would have thought differently and rejected these arguments, buried now in decisions that the scholars seem to have rejected. I'll have to reserve for another time some of those engaging older cases with crusty judges like Owen Roberts and Rufus Peckham, of whom Holmes used to say his major premise was, God damn it. And he just extrapolated from there. And what's so serious that as the social scientists say, it took in about 85% of the variance. He got it, you know. It was a very serviceable major premise. Now, but with the press of time and people coming in, I'd approach the problem from a rather different angle as I go back to another notable decision that's been caricatured and regarded as deeply discredited. And what I'd ask you to do is, some of you who've read these cases may spot the case I'm describing and say, I invite you to shout out when you know what it is. Gary probably knows these things. Now, it shouldn't surprise people that judges, writing carefully, will try to frame more precisely the kind of judgment they're reaching in the case at hand, so that the holding doesn't seem to flow over carelessly, to cover things they never meant to reach. And with that care, they'll usually seek to show how the judgment they reach in this case can be reconciled with the judgments they handed down in the past. That discipline has as its purpose the point of showing that the judges hold themselves as obliged to respect the rules they've articulated in the past, that they're not claiming a freedom just to make up new rules from case to case. Remember Frankfurter's old lament, we are not coddies sitting under a tree, you know. We've got to explain the reasons and how this connects with what we did on Tuesday. You know? And yet, that is exactly what was filtered out in the accounts of the reasoning put forth by the supposedly conservative judges at the end of the 19th and 20th century. So let me take one notable example to offer you. I'll draw some lines of this kind from that case, and it may be, again, an interesting puzzle for those who've studied constitutional law. You probably will see what this is. If I assembled the points that the judges are encompassing, to what conclusion is it pointing? And how soon could you identify the case? So the opinion was framed in this way by the jurist writing for the Supreme Court. The jurist noted that it was a clear violation of the 14th Amendment, an abridgment or denial of equality under the Constitution, when West Virginia limited the membership on juries to white male persons 21 years of age and citizens of the state. He noted that there had been a law in Louisiana that had provided that all persons traveling in that state upon vessels engaged in the carrying of persons should have equal right and privileges and suffer no discrimination based on race or color. That provision, said the judge, posed no constitutional problem. It was wholly within the power of the state to forbid that racial discrimination among passengers. Okay. He notes that where the laws of the state or the charter of a private company provided that no person shall be excluded from cars on a railway on account of color, the law was not respected when passengers of different races were compelled to travel in different cars, assigned exclusively to people of the same color. Nothing in the Constitution barred the legislature from passing laws of that kind, mandating the equal treatment of the races, and from insisting on the exacting enforcement of the statute. Do you know the case? It's Plessy. It is Plessy. For my own students, it comes as a surprise, to put it mildly, to discover that this was the reasoning in Plessy versus Ferguson. And that case has been quite infamous, become infamous, of course, as the case reputed to have mandated separate but equal. It was the case supposedly overruled in Brown versus Board, but the phrase separate but equal did not spring from anything in the reasoning of the judges. The question before the court, as Justice Brown noted, was whether this kind of a separation accorded with the kinds of separations that legislators and judges found reasonable when set against the established usages and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Now, as Brown showed, he and his colleagues were quite prepared to enforce policies that mandated a stringent equality of treatment, policies that forbade, in no uncertain terms, any discriminatory treatment or separation of the races on public railways. And with that sense of the matter, Brown made it clear that the court would not countenance any schemes suggested as hypotheticals in which a legislature would mandate that colored people walk on different parts of the street, or require that white men's houses be painted white and colored men's black, or their vehicles or their business signs be of different colors. These schemes were, of course, reminiscent of those Stars of David the Jews were forced to wear in Nazi Germany, to mark them off as a stigmatized people. And that was a sense of Brown's sense of the matter, that this is simply a gratuitous gesture to injure and to denigrate, and bore no plausible connection to any legitimate interest of the state. Okay. Well, why was it reasonable to separate the races in railway cars? And again, the interesting thing here is the court was not canvassing the sentiments of judges. For the judges thought it was apparently quite as reasonable for the legislature to insist that there be no separation in public railways. The question was, what degree of discretion lay within the authority of the legislature as it judged what was fitting and reasonable? But that question would be measured, as Brown said, not by consulting the feelings or estimates of judges, but by considering what was regarded as reasonable according to the established usage, customs, traditions. And as Brown and his colleagues made clear, it would not suffice in answering this question to cite the established uses, customs, and traditions in the South, in enclaves showing a deep, lingering racial prejudice. As the judges weighed the standards at work here, they consulted the standards for what was regarded as reasonable by judges and legislatures in the North, and by the men who had framed the 14th Amendment itself. And as the judges canvassed the precedents, they found a host of decisions in the country, decisions that sustained as reasonable and legitimate the separation of the races in public railways. They found those judgments rendered by courts in Illinois, Michigan, Pennsylvania, as well as in the border states of the South. They found that one single case, of course, of the separation of children in Massachusetts, the case many people here know, Roberts versus City of Boston, with that preeminent anti-slavery jurist, Lemuel Shaw, Herman Melville's father-in-law. For Shaw, drawing on the temper and the moral sensibility in liberal Massachusetts, the decision of the city council in Boston to provide for that separation was no meaner, no less legitimate than the judgment of that same body that it was reasonable to separate the children in schools on the basis of sex or on grounds of age and ability, to seem to them all of a piece. That decision had come before the Civil War, but it could not possibly have gone unnoticed by the judges that the same judgment would be seconded by the men who had framed the 14th Amendment. The Congress that passed the 14th Amendment had a plenary authority over the District of Columbia. And as John Noonan would later observe, it was hard to credit the notion that the same men who passed the 14th Amendment thought that the logic of that amendment barred the segregation of children in the public schools in Topeka, and when they did not think that the same amendment barred the segregation of children within the schools of the District of Columbia, which came under the exclusive control of Congress. And yet, even more than that, the judges in 1896 were close enough to the experience to know that Lyman Trumbull and the drafters of the 14th Amendment assured their colleagues up and down that nothing in that logic of the 14th Amendment could possibly threaten those laws on miscegenation in Illinois, Indiana, and other places that barred marriage across racial lines. Those laws were as important, were taken as quite as seriously, I guess, again, in Illinois and Indiana as in Kentucky and Alabama. And as everyone knew at the time, there wasn't a ghost of a chance that the 14th Amendment would pass if Trumbull could not offer those assurances to his colleagues. And so we put this together. We say, how did this look to judges in 1896 who were weighing the question, looking beyond their own sentiments for guidance? It had to be clear to them that in the judgment even of the most liberal statesmen and judges in the North, the 14th Amendment could not forbid legislatures from providing for the separation of races in marriage, in public schools, and in public conveyances. That's how it looked. Unless the judges were able to come up with some compelling principle appealing to a deeper logic, the limited question before the judges rather settled itself. This might not be the arrangements that accorded with the sentiments of the judges, but they could not say in any honest canvassing of the understanding of the time that the Constitution clearly forbade the judgment made in this instance by the legislature of Louisiana. Now, curiously, Steve Calabrese, one of the founders of the Federalist Society, mentioned Plessy a few months ago as he was celebrating the Federalist Society and its doctrine of originalism. He remarked that Plessy showed the need to overturn certain cases, and that Plessy had to be torn out, root and branch. But even Steve, one of the most careful students of the law, had forgotten the finer grain of reasoning contained in the Plessy case and had not noticed that the mode of analysis used by the court was just about perfectly in accord with the style of that originalism that the Federalist Society has been urging upon us. Okay? Now, of course, some of us think that there was in Plessy an appeal precisely to that deeper logic in that famous stirring dissent offered by the first Justice Harlan. That was the opinion in which, you probably recall, that Harlan declared that the Constitution was colorblind, that there is no caste here. And as Harlan argued in those lines that resonate, in the view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There's no attempt here, as Harlan said, to legislate social equality, for there's no implication that citizens stood on the same social plane when they stood together in legal offices or as members of juries. So he went on to say that the arbitrary separation of citizens on the basis of race while they're in a public highway is a badge of servitude, wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified on any legal grounds. Harlan was quite emphatic on the point that race was inadmissible for creating tiers of rights among citizens. But was race equally admissible in creating tiers of rights, equally inadmissible in creating tiers of rights among persons, as in determining just which class of persons could get access to the rights of citizenship? And in the sweep of this opinion and the design of his argument, Harlan remarked that there is among us a race so different from our own that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it, with few exceptions, are absolutely excluded from this country. And you know who that is, I think some of you, right? The Chinese. And there's no case, as far as I was looking into this years ago, there was no case involving the illiberal treatments of blacks and Indians in which he was not in dissent. There was no case involving the illiberal treatment of the Chinese in which he was not with the majority. And so the line was, for God's sakes, you let even a Chinaman sit next to you on a train. And you won't let a black man who perhaps fought to preserve the Union. Harlan's sentiments, by the way, that passage I found excised from a number of case books. Rather curious that they would leave that one out when it raised the question of whether he was clear about the ground of the judgment he was offering. Harlan's sentiments were rightly animated, but it's arguable at the same time that he never really provided the explanation in principle, the explanation running to the root, the explanation of why it was wrong to draw moral inferences about people on the basis of race, and on the basis of race then assign benefits and disabilities. The want of that argument may not only explain why Harlan's dissent offered no particular help to the court in later years, and they keep pointing out to us later on with affirmative action and racial, no, we never did accept Harlan's argument in Plessy versus Ferguson. We never accept, we're not saying the Constitution is colorblind. Justice Kennedy insists on this one. Right? It may also count for why it offered no guidance when the judges in the 1940s and 50s were searching for some way of explaining whether segregation on the basis of race was not only wrong in relation to this particular case involving the condition of schools, lunch counters, or swimming pools, but whether there's something in principle wrong with discriminations based on race. The late Bill Hastie, a federal judge, was a trustee of my college. He was part of the NAACP team arguing those cases in the 30s and 40s. And Bill Hastie recalled one time he was arguing one of these cases, and the scheme was to make them as narrow as possible. And Wiley Rutledge leaned in and said, but Mr. Hastie, wouldn't you say this separation is wrong in principle? Well, we might, Your Honor, but that's not the argument we're offering today. And 10 minutes later, Wiley Rutledge leaned in again and said, but Mr. Hastie, wouldn't you say? And then Bill said, I gave him 12 minutes of pure bullshit so that he would never ask me that question again. We are not doing that today. And after years of not doing it, they forgot how to do it, I'm afraid. Looking back to the Brown case, the judges were often befuddled by the question of whether the wrong here was merely a contingent wrong. Was it wrong to separate children on the basis of race because we might impair the performance and the progress of children in the schools? But if we separated them on the basis of race and their reading scores went up, would the segregation have ceased to be wrong? Or would we say that there's something in principle wrong with the discrimination based on race, a wrong that would not be effaced, say, if the segregation worked to deliver benefits to black people? My own judgment, as some people here know, is that the wrong of racial discrimination was indeed a wrong in principle, that it was rooted in the very logic of law and moral judgment. I forbear laying out here the case I've been offering over the years, but I'd offer this compressed account just for the moment. I've argued that behind the will or the passion to discriminate on the basis of race is a species of determinism, the notion that race exerts a kind of deterministic control over the character and conduct of persons, so that if we know someone's race, we think we can draw some interesting moral inferences about him, whether he's on balance a good or a bad man, whether his presence in the community would improve or diminish it. To know someone's race on these premises is to know something about the people more fitting in any place, more deserving of promotion or neglect. In short, we'd have the clearest ground for assigning benefits and disabilities to people. But if this sense of things were true, well, none of us could plausibly bear responsibility for his own acts. Our conduct is determined by our race. There'd be no ground for disapproval or approval, so for censure or for rewards. It might be said in this respect that the willingness to discriminate on the basis of race denies that moral autonomy or freedom that is the very premise of our standing as moral agents. If we were not in control of our own acts, we would never deserve punishment at the hands of law, and neither would we ever deserve praise. It's an axiom of the law, and indeed of moral judgment, that we may not hold people blameworthy or responsible for acts they were powerless to effect. And so in all strictness, it could be said that if discrimination on the basis of race were not wrong, then nothing, I submit, nothing literally could ever be wrong. For there'd be no plausible standards of right and wrong to which persons may be held accountable. The whole language and logic of moral judgment and legal judgment would be stripped of its meaning. These words of right and wrong would be reduced to the oddity of words without meaning or function. They may apply a vague approval or disapproval, but not strictly a ground for casting judgments of right and wrong. The judges over many years were reaching out for something of this kind, and at times they came close. And yet they never did quite break out of that scheme of identifying the wrong in any case as contingent. Contingent, that is, on the injuries that could be produced in the schools or on the assignment of jobs. I recall a venerable professor of law at the University of Chicago. Actually, Tom, I think by these years we could name it. Phil Curland. Remember Phil, remember musing about this and say, well, how do the judges move from wrong of segregation in the schools to swimming pools? Are you suggesting that being segregated on the basis of race in the pools will impair the performance of children in the schools? You know? To listen to the lawyers, one would have thought that we needed a special principle in each case. And so if black people were restricted from access to public tennis courts, we'd have to articulate a constitutional right to play tennis. And what I've argued over the years is that the judges have kept confusing here principles with the instances in which they may be manifested. Once I'm clear on the principle by which that ball rolls down the inclined plane and is affected by the angle of inclination, will it work with yellow planes and blue planes and wooden planes and plastic balls? There may be access to maybe racial discrimination and access to tennis courts, swimming pools, copying machines. But what we should grasp here is that we have the same principle at work, a principle that could be manifested in a numberless variety of cases. It may be lunch counters or clubs or ballparks or computers, but it's the same principle engaged. And we need not strain our wit to explain any distinct importance in ballparks or computers. And yet that confusion has persisted remarkably among our jurists. And there's probably no more dramatic case in point under this head than the case that provides my final case and carries me through to my summation or summation of this argument. The case that stands here so tellingly, to my mind, is Loving versus Virginia in 1967, when the Supreme Court confronted a case arising out of the old laws of Virginia, the laws on miscegenation barring marriage across racial lines. In this instance, there was a law that barred marriage of a white man, Richard Loving, and Mildred Jader, a black woman. When the case reached the Supreme Court, Chief Justice Warren opened it in this way, and she said, "This case presents a constitutional question never addressed by this court." A case never addressed by this court? The court has never yet addressed a case involving discriminations in the law based on race? Or a case concerning marriage? You've never done that before? I raised the question once of what the judges might have done if the case involved a law in Virginia that forbade business partnerships across racial lines. And I imagined the case of two friends, black and white, who purchased together a delicatessen. And I called the case Zabars versus Virginia. Well, the judges have said, we've never seen a case like this before. We've never dealt with a case of delicatessens. And when they struck down that law, would they have articulated a new constitutional right? A right to own a delicatessen. Well, as I have the occasion to argue, it made as much sense now for the judgment that the judges announced here that the case brought forth a new right to marry. And as the judges acknowledged, that so-called right to marry could be restricted at many points, as the law forbade the marriage of children, incestuous couples, couplings across species. I was just told by a friend in Denver of somebody who appeared at the Marriage License Bureau seeking a marriage license for himself and his horse. And I'm proud to tell you that I guessed the reason tendered by the clerk for refusing the application, which is the horse wasn't yet 18. As the judges acknowledged, this so-called right to be married could be restricted at many points. And so the drift of the judges into new confusions of marriage was a sign of the fact, once again, that they'd never been clear on the principle of the case. For if they had, they would have recognized that this case could have been resolved without saying a word about marriage. You didn't need it. It was simply racial discrimination in another instance. And then they've been explaining why that case never precluded other restrictions based on race. A fundamental right, but of course it could be restricted at many points. Just as the case of the partners in business would have been decided without saying anything about a right to own a delicatessen. But when we're alerted to the problem in this way, it becomes revealing and it begins to open a further window into the understanding of the judges. When we ask, what did they finally say about racial discrimination? Where did the wrongness lie? And in dealing with that question, decisive to the case, Chief Justice Warren stated the matter in this way. He said, there could be no question but that Virginia's miscegenation statutes rest solely upon distinctions drawn according to race. The statutes prescribe generally accepted conduct if engaged in by members of different races. And indeed, two members of this court have already stated they cannot conceive of a valid legislative purpose which makes the color of a person's skin the test of whether his conduct is a criminal offense. The Chief Justice stated, as his leading point, that this court has consistently repudiated these discriminations based on race. That is, he does not explain the ground of the wrongness. He merely reports that he and his colleagues have rejected that discrimination in the line of cases. But really? You had consistently repudiated those discriminations? Well, clearly not. Because the court had upheld those distinctions, after all, in Plessy. And the judges, by and large, sustained those kinds of discriminations until a slight turn beginning in the 1930s. And so what Warren really meant was that the judges, over the preceding 20 or 30 years, had rejected those discriminations. In a rough estimate, we're talking about a cohort of 29 judges sitting on the Supreme Court. And just about all of those 29 were willing to reject racial discrimination most of the time, not all. That was quite different from saying that discrimination was categorically wrong in principle, and still less close had the judges come to explaining how something could be categorically wrong in all instances, virtually regardless of the effects in any case. Warren noted that the lawyers for Virginia argued that the law in Virginia did not violate the Equal Protection Clause because it bore equally on both races. It barred white people from marrying black people and barred black people from marrying white people. Right? And the state here cited a case from the 1880s dealing with the punishment of adultery and fornication in Alabama, where the court essentially made that argument. It satisfies the equal protection of the laws because it bears equally on both races. But there was a certain sleight of hand here on the part of the Chief Justice, because he certainly must have known that this was not merely the opinion of the argument made by lawyers in Virginia. This was the judgment of Lyman Trumbull, the framer of the 14th Amendment, as he explained to his colleagues why that 14th Amendment would not challenge those laws on miscegenation in the state. It wasn't simply the argument of it was the understanding of the people who had framed the 14th Amendment. Okay? Now, the awareness of that argument, or that state of affairs, should have obliged the judges to do something, have done something more strenuous and demanding here in finally supplying the argument. But when we take this omission, what they passed over in the sleight of hand, when we take it in its proper setting, when we take note of the alternatives before the court, the depth of the problem reveals itself more clearly and dramatically, I would suggest, as the moral problem it is. Consider the problem now, arranged in these alternative strands of judgment that were available to the court. The Chief Justice, Warren, thought he was articulating something novel as a constitutional right. Where could he look for this new constitutional right? He couldn't find it in the text of the Constitution, right? Lacking any foundation in the text, it's customary to look at the understanding of the men who framed the law. As Lincoln used to say, the intention of the lawgiver is the law. Well, he couldn't do that. That was against him. But these points of no small importance don't close the problem. Another path of exposition begins with the recognition, of course, that none of us realistically can claim to know all of the implications that spring from our principles. You know, the life of moral judgment is a life in which we may constantly become aware of implications of our own principles that have gone heretofore unnoticed. It's not a knock on Lyman Trumbull and company that he didn't see all the reach of those principles. We can be grateful for what he did in getting in planting the principle in the first place. Okay? But if you add this thing up, I suppose, you know, Trumbull and company could have said they understood that argument, but they're making a prudential accommodation with the views of their constituents. As Lincoln said, a passion running deep among the people cannot safely be ignored. And this was one of those they had to recognize. And words of that kind could have been set down by the court in making the case in principle and saying, Lyman Trumbull did not encompass it, but we submit that is consistent, quite consistent with the understanding contained, the logic contained in the 14th Amendment. But when we understand the path that the court took, and the path that never seemed to come to light for the judges, we may see then more starkly the choice they made. The judges realized that they could not cite on their side the text of the Constitution. They could not cite the 14th Amendment. They could not cite the understanding of the people who framed the 14th Amendment. They simply cited the judgment of 29 men who had been on the court. 29 of us decided it this way. When the matter is finally posed in that way, we may earnestly ask, why should the judgments of those 29 be given precedence over the text of the Constitution, the understanding of the framers, the understanding of several hundred congressmen and senators who voted for it, if we're not making an argument in principle to explain the principle behind this thing? If we're simply counting heads and pointing, 29 of us have decided it this way. If we remove from the problem the principle that explained the wrongness, finally of racial discrimination, if we put that matter entirely out of the picture, on what conceivable ground could we say that this bunch of 29 judges should rightly be given an authority that transcended all of the rest? Is there some magical number about 29? Nor could it be that there were more recent judges pronouncing on the more recent cases, because for the main logic of a constitution is that the principles of the Constitution established in the text restrains the things that legislators and judges in our own time may rightly do. But wanting any other explanation, the possibility must hover that the only ground for this assertion of authority for the recent band of 29 guys is that the judges now on the scene have indeed in their hands the power to make decisions that are obeyed. And have those decisions obeyed when they disregard text of the Constitution, break from their own precedents, and depart from the understanding held by the framers of the laws. But when stripped in that way, that is, we say, not making the argument in principle, but doing it this way, and cleared of legal language, the claim of the judges seems to reduce to the claim brought forth and rejected so tellingly by Rousseau, that power itself cannot be the source of its own justification. Or the opinions of those 29 judges prevails because they simply had the power to hand it down. In the case of Brown versus Board of Education, the court could have taken the occasion to explain that principle on racial discrimination and do something similar to what I've set out down here. Once again, the right decision was made, but on grounds that were even more curious and possibly more disturbing than the reasoning in the case of marriage. Because instead of making the appeal to the deep principle of the 14th Amendment, as you probably know, the judges made an appeal to social science, the finding of social science, that children in more segregated schools were more likely to reject their own blackness and to fall to the acceptance of themselves as members of a lower caste. But the embarrassment of this argument, brought forth by several commentators, was that the social science cited by the court pointed in a direction quite opposite from the conclusion drawn by the court. Because in the experiments of the sociologist Kenneth Clark, it was the children in the more integrated settings in Massachusetts who were more likely to reject their blackness or evince a sense of hurt in the awareness of their race than the students in the more segregated settings in the South. And so the variation added by the court here might have been even worse than the performance in Loving versus Virginia. The judges could not rely on text or legislative history. They would not engage in the exertion of explaining the principle that made racial discrimination categorically wrong in all instances. They would lean instead on social science, and when the social science yielded findings at odds with their conclusions, the judges would simply declare that they themselves would pronounce on the truths to be gleaned from social science, even when those truths were at odds with the findings reported by the social scientists themselves. By the time we have laid bare these strands of judgment, it should be clear that whatever else they describe, they do not describe the vocation of jurists, concentrating their learning and their wit on explaining those deep principles that finally govern our judgments on the things that are just or unjust, right or wrong. We would find, in short, a description of power without discipline or restraint, power that feeds on itself and cites power alone as the source of its justification. Recall during the hearings on John Roberts, when Ted Kennedy was trying to draw John Roberts into an argument of an effects test, that can we find racial segregation wrong, even if it just produces ill effects, and said, didn't they have that in Brown? And of course, there's no evidence in Brown about the effect of segregation on the performance of children in those schools. There's no evidence at all on that question, and apparently Ted Kennedy was utterly unaware of the fact that that just wasn't contained in Brown versus Board. So, my pitch here is that the things I've drawn from these cases are often at odds with the prevalent view of what these cases mean or what they've established in our law. And what I brought out in these cases runs counter to the caricatures or the cliches that have fixed the meaning of these cases, whether those decisions have been condemned as reactionary or praised as progressive. And either way, the reasoning of the judges, read closely, seems to have faded from our view when the cases have been folded into some grand historical account of what the court had done in different epochs or the motives that it might have been driving the judges. The reading of the cases has persistently belied those commentaries, those caricatures. The Marxist with a suspicion of the bourgeois interests of the judges, the New Dealer with his suspicions of natural law simply can't give us a faintly plausible rendition of Owen Roberts' judgment in U.S. versus Butler. We don't know where our authority comes to set the wages and prices in the Hoosac mills, so we'll tax you and give you back the taxes. We'll remit it if you accept federal policy. So as Owen Roberts says, they're inviting us to buy back our own freedom. It's like saying, we'll tax abortion clinics at 100% and remit the tax if you'll accept these kinds of restraints on abortion which the court has not allowed that we can enact. Right? That's that sort of thing. My old teacher, Leo Strauss, in a lesson now grown familiar, used to encourage us first to understand people as they understood themselves, okay? Before we launch our own critiques of what they've done, or before we presume to speak of their motives as an alternative to dealing with their arguments. But to understand the judges, to understand these judges as they understood themselves, is to show the patience first to attend seriously to the reasons they've given and the way they've shaped their arguments. And I've suggested here that we're more likely to avoid a false account if we start with an assumption that seems to run counter to the fashions of our day, instead of locating the judge in his historical epoch or looking for his class interests. I suggest we start with the assumption that the reasons he sought carefully to assemble may still be as plausible or implausible as they were when he had set them down. His colleagues in dissent were free to be unpersuaded at the time and to explain why those reasons failed to persuade. We're as capable of entering that conversation, I submit, on those terms as the judges were when they listened to the arguments and sought to form their own judgments. But if that's the case, we could begin with the understanding that we're engaged in an ongoing conversation. The things said by Sutherland in the 1930s are still in play. That conversation can genuinely take place across the generations. In the same way that we read Plato and Aristotle because we think they have something to tell us, something that illuminates the problem of our politics, we may read the opinions in these cases as though they contain reasons or understandings that can finally command our judgments as validly today as they did when they're set down. Remember, Lincoln famously said in the Cooper Union speech, talking about the founders, that the founders understood the situation, our problem, as well as, or better than, we understand it today. No, the founders didn't anticipate the problem of research on embryonic stem cells or the complications wrought by emails and computers, but they understood that any device, any act, anything we could name, a pencil, a car, a carriage, could be directed to a wrongful purpose. The founders understood that people could seek to relieve their own conditions or dissolve their own predicaments at the expense of others or by sacrificing the lives of innocent people. The very notion of a constitution implies that one finds a certain wisdom in being ruled by an earlier generation of statesmen with uncommon judgment. A constitution means that we constrain the exercise of power by people known to us today because of certain impediments and disciplines put into place by rather uncommon men with the furnishings of mind shown by James Wilson, Alexander Hamilton. And that means, in effect, that in the most practical way, we'd rather take our chances with Hamilton and Wilson, even when it means restraining the decisions made by Ruth Ginsburg or David Souter or Harry Reid and Mitch McConnell. And yet none of that makes much sense unless we suppose that there's a political truth or a wisdom about the way we live that can hold across the generations. That's possible to have that conversation across the generations about the terms of principle in which we live. The central question in that conversation has always been about the grounds on which we form our judgments about the things that are just or unjust. And the circumstances or the instances may have altered, but the principles remain the same. Chesterton once remarked that the purpose of education was to make young people old. Or to put it another way, as he said, it delivers young people from the servitude of being children of their own age. Yeah. And in that vein, we might say once again that we could show a better judgment if we began at least taking seriously the possibility that those statesmen and judges of an earlier time, even those judges who've been swept aside by the sweep of history, that even they may have understood our current situation as well as we understand it ourselves. Thanks very much.